Channel EduTap. I am Arshdeep Kaur, and today we start with the Code of Civil Procedure. We will be dealing with the important questions from this code. So the CPC is very important from your examination point of view. So we will be dealing with the CPC today. It is part 1 of CPC. Before I start, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2. It will be very helpful for your revision. What all is included in it? It is chapter-wise test, sectional test and full-length test. We have also come up with a live crash course on both the phases, phase 1 and phase 2. It will include live classes, test series I just mentioned, and you also get one-on-one mentor support. We are running a limited time period offer, so if you want to avail this offer, kindly refer to the link in the description below. Now let's start with our lecture. Question number 1. Courts have jurisdiction to try all the suits of civil nature except suits, the cognizance of which is either expressly or impliedly barred by the virtue of, it is C, that is section 9 of CPC. So the courts shall implies that there is jurisdiction, right? So what does shall mean here? That there is jurisdiction, and whoever who wants to deny this jurisdiction, he has to prove it. The court shall have jurisdiction to try all the suits of civil nature. They will have the jurisdiction to try all the suits of civil nature. What is a suit of civil nature? For example, related to sale, related to salary, related to damages, right? Related to the specific performance. So these are what? These are all civil in nature. Except suit of which their cognizance is expressly or impliedly barred. Except those suits which have been expressly or impliedly barred. By who? Either by CPC or any other law for the time being in force. So section 9 reads as, courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature except suits of which their cognizance is either expressly or impliedly barred. Question number 2. Doctrine of res sub judice is provided under which section? It is section 10. Section 10 does not talk about res sub judice. It does not mention this term, but what it says is, it says stay of suits, right? It mentions stay of suit. What is res sub judice? If we divide these terms, res means matter and sub judice means under judgment. So a matter which is under judgment before a court, it cannot be filed. It cannot be filed in another court, right? So if we read section 10, it says it is bar on the court. The court cannot try a suit that is pending with a former court, right? So the suit, the subsequent suit, it cannot be tried by the court if it is pending between the same parties, between the same title, between same cause of action, and if it is pending with a former suit, former competent suit. So it bars the subsequent court to try that suit, right? Let's read it. Section 10 requires that a suit must be stayed if the matter directly and substantially in issue in it is also directly and substantially in issue in a previous suit that is pending. So the suit, if it is pending, right? So if it is pending and if the subject matter is same, then in that case it cannot try the subsequent court, it cannot try the same matter. The criteria for deciding whether the subsequent suit be stayed or not is whether there is identity of the matters directly and substantially in issue in the two suits. If there is, the subsequent suit must be stayed, and if there is not, it will not be stayed, right? So what is the object behind this section? It is to avoid parallel litigation. So in the future, two conflicting decisions do not come up, right? So that is why it is important that the subsequent case, it shall not be tried by the subsequent suit. The same case shall not be tried by the subsequent court, right? And the stay of grant is on who? It is on the subsequent court. So the subsequent court. So the stay will be on the subsequent suit filed, right? Question number 3. Which one of the following sections of CPC deals with the institution of suit? It is section 26. Every suit shall be instituted by presentation of a plaint, right? So it will be instituted by how? It will be instituted by a presentation of a plaint or in such other manner as may be prescribed. What is such other manner? For example, in Hindu Marriage Act, it is not called plaint, it is called a petition. So that is what they mean, right? Or in any other manner as has been prescribed. In every plaint, facts shall be provided by the affidavit. They shall be provided by affidavit, provided that such an affidavit shall be in the form and manner as prescribed under Order 6, Rule 15A. Question number 4. A decision or findings given by a court or a tribunal without jurisdiction. It does not come under res judicata. It does not operate as res judicata. Right? So the pivotal condition of res judicata is that the court which decided the former suit must have been a court competent to try the subsequent suit. Thus, the decision in a previous suit by a court not competent to try the subsequent suit will not operate as res judicata. So what is res judicata? Again, res, I have told you, res means matter, and judicata is something that has already been decided. So something which has already been decided, it shall not be tried by another court. So this is what res judicata means. So it is basically a bar on the jurisdiction of the court, that it cannot institute, that it cannot try a suit that has formally been conclusively decided. It has been decided on merits. It has conclusively been decided by a competent court, and the court which decided it, it should have been what? It should have been a competent court. In that case, if the parties are same, if it is between the same parties, if they are litigating under the same title, and if they are litigating for the same cause of action, then in that case it is bar on that subsequent suit. That suit, it cannot be tried by another court if it is finally decided by the previous court, right? What is finally decided? Finally decided has three implications. Finally decided means where an appeal does not lie. That means it has been finally decided. Or it means that an appeal lied, but the parties did not exercise their right to appeal. Or in third case, where the appeal lied and they exercised their right to appeal as well, but it was dismissed by the appellant court. So this is what? This is final decision. So if it has been finally decided, then another court, a subsequent court, it cannot try this suit. So this is what res judicata means. So the answer here, where the tribunal, they are talking about where the tribunal that decided a case, it was not competent, right? It was not competent to give that decision. In that case, what will happen? In that case, it will not operate as res judicata. So it has to be a speaking order. What is speaking order? Matlab, it has to be given on the merits of the case after hearing the both the parties. Then only it can operate as res judicata, and it has to be a speaking order, and it has to be a court of competence, that the court has the competency to try that suit. Then only it will be operated as what? It will come under res judicata. Question number 5. Under section 15 of CPC, every suit shall be instituted in, it is the court of the lowest grade, right? So every suit shall be instituted in the court of the lowest grade competent to try it. Why the lowest grade? So that the higher courts, they are not burdened, they are not crowded with the cases, right? Let's read it. The objective of this provision, by requiring a suitor to bring his suit in the court of the lowest grade competent to try it, is that courts of the higher grades may not be overcrowded such suit. At the same time, it does not oust the jurisdiction of the courts of higher grade. They do not oust the jurisdiction, they do not take away the jurisdiction. But the higher grade courts should return the plaint in such case to the plaintiff to be presented to the court of the lowest grade competent to try it. So if a plaint is presented to a higher grade court, what will that court do? It will return the plaint to the original court where it should have been lied, right? Where it should have been taken up. Question number 6. Place of suing in respect of suits of compensation for the wrong to person or immovable or movable property has been dealt with. It has been dealt with section 19, right? Let's read this section. What does this section say? So where a suit is for compensation, it is for compensation for wrong done. It is wrong. So it is an actionable wrong for which you get compensation. Where a suit is for compensation for wrong done to the person or movable property. The subject matter can be either a person or movable property. They are not talking about the immovable property. If the wrong was done within the local limits of the jurisdiction of one court. The wrong done means where the cause of action arose, right? And the defendant resides or carries on business or personally works for gain within the local limits of jurisdiction of another court. If he is residing in another place and cause of action arose in another place, then in that case, the suit may be instituted at the option of the plaintiff in either of the said courts. So it can be instituted in either of the said courts, either where the defendant is residing or where the cause of action arose, right? A resides in Delhi, beats B in Calcutta, B may sue A either in Calcutta or in Delhi. A residing in Delhi publishes in Calcutta statements defamatory to B. B may sue A either in Calcutta or in Delhi, right? Question number 7. Objections as to the place of suing. The answer is A, that is only A is correct, can only be taken before the court of first instance at the earliest possible opportunity. This is section number 21. Let's read this section first. No objection as to the place of suing. So they are talking about territorial jurisdiction here, right? So no objection as to the place of suing shall be allowed by any appellate or revisional court. So no court, which is appellate court or the revisional court, it is not going to take your plea of objection of jurisdiction, right? So no objection as to the place of suing shall be allowed by any appellate or revisional court unless, but there is an exception, unless such objection was taken in the court of first instance. Unless it was taken up there, right? It was taken by the court of first instance. It was taken up before the court of first instance at the earliest possible opportunity. At the earliest possible opportunity means that the defendant came up with it. So defendant came up with it in the written statement only. He mentioned it in the written statement. So that is what, according to the Supreme Court, it is the earliest possible opportunity. And in all cases where issues are settled at or before such settlement, or in case the issues they have been framed, if in case they have been framed at that stage, you have to bring that objection, or in case they have not been framed yet, then before that, right? So in case where issues are settled at or before such settlement, and unless there has been a consequent failure of justice. So the sole determining factor has to be the consequent failure of justice. In case there has been no such failure, then any other condition that we have read, it comes to negative. So any other conditions that we have read, they become void, right? They are not applicable here. So just because there was a consequent failure of justice, then only this section is going to come into play, and then only the other conditions will be seen. Then only the other conditions are going to be checked. So there has to be a consequent failure of justice. If no such injustice is caused, then this section does not come into play. So the first one, they are talking about the place of suing. Second one, they are talking about the pecuniary limits. The whole of the subsection is same. And the third one, they are talking about the territorial jurisdiction of the executing court. Let's just read it, and now this will be clear to you. So the second one says, no objection as to the competence of a court with reference to the pecuniary limits of its jurisdiction shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement, and unless there has been a consequential failure of justice. Same as subsection 1. No objection as to the competence of the executing court with reference to the local limits of its jurisdiction shall be allowed by any appellant or revisional court unless such objection was taken in the executing court at the earliest possible opportunity, and unless there has been a consequent failure of justice. So everything else remains the same. The first one is only talking about the place of suing, the second one pecuniary limits, and the third one competence of the executing authority with reference to the local limits. Question number 8. According to section 27 of CPC, summons to the defendant to be served on such date not beyond. It is beyond 30 days. Let's read it. Where a suit has been duly instituted. What is duly instituted? It means that all the conditions have been met with and you have received your case number. So this is what duly instituted. A summon may be issued to the defendant to appear and answer the claims. So why he has to appear? He has to appear and he has to answer the claim and may be served in manner prescribed on such day not beyond 30 days from the date of the institution of the suit. So it cannot be beyond 30 days from the institution of suit, right? So the answer is option A, that is 30 days of the date of the institution of suit. Question number 9, decree holder. So what do you mean by decree holder? Let's read it. I have mentioned here both decree holder and judgment debtor. Decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. So in whose favor a decree is passed, he is known as what? He is known as decree holder. And against who the decree has been passed, he is termed as what? He is known as judgment debtor. Judgment debtor means any person against whom a decree has been passed or an order capable of execution has been passed. Question number 10. Which of the following statement is incorrect? A decree may be executed either by the court which passed it or by the court to which it is sent to the execution. The court which passed a decree cannot, of its own motion, send it for execution to any subordinate court of the competent jurisdiction. Court shall be deemed to be a court of competent jurisdiction if, at the time of making the application for the transfer of decree to it, such court would have jurisdiction to try the suit in which such decree was passed. The court which passed a decree is not authorized to execute such decree against any person or property outside the local limits of its jurisdiction. So the answer is option B. The statement mentioned in option B, it is incorrect. If we read section 39, it says that the court which passed a decree may on its own motion send it for execution to any subordinate court of competent jurisdiction. So it can be sent to a subordinate court also if it is competent to have that decree executed, right? So the court which passed a decree may of its own motion send it for execution to any subordinate court of competent jurisdiction. Question number 11. A resides at Shimla, B at Calcutta and C at Delhi. A, B, C being together at Banaras, B and C make a joint promissory note payable on demand and deliver it to A. A may sue B and C at, it is E, that is Calcutta, Delhi or Banaras, any of these. We will go through the section first. It is section 20. So subject to the limitations aforesaid, every suit shall be instituted in a court within local limits of whose jurisdiction. So where a suit is going to be instituted, the defendant or each of the defendant where there are more than one at the time of the commencement of the suit actually and voluntarily reside or carries on business or personally work for gain. If there are more than one defendants, then where each of such defendant resides. Any of the defendants where there are more than one. So where there are more than one defendants and each of those defendants, they are living in different areas. So what will happen is at the time of the commencement of the suit actually and voluntarily resides or carries on business or personally works for gains, provided that in such case either with the leave of the court is given, either with the permission of the court in one such area where one of the defendant is residing, right, with the permission, with the leave of the court, or the defendants who do not reside or carry on business or personally work for gain, or if the non-residents, they agree to one place, right, they agree to a place where they are not residents. In that case, that jurisdiction will be final. In a case where they are unable to come to that agreement, right, they cannot agree on one place, then it will be with the permission of the court, it will be with the leave of the court. The cause of action wholly or in part arises, or where the cause of action arose, right? So that is why it was also Banaras where the promissory note was executed. So that is why where the cause of action wholly or in part arises. A corporation shall be deemed to carry on business at its sole or principal office in India. So a corporation will be deemed that where it has the head office, there it will be deemed that it carries on its business, or in respect of any cause of action arising at any place where it has also a subordinate office, or for example that it has a branch in some area and there the cause of action arose, so that will also be deemed where it carries on its business, right? Let's read it again. A corporation shall be deemed to carry on business at its sole or principal office in India or in respect of any cause of action arising at any place where it has also subordinate office at such place. Question number 12. Which of the following are exempted from the arrest and detention under the various provisions of CPC? The answer is all of these. I have actually enumerated the list. Let's go through it, that who all are protected, who all cannot be arrested under CPC. It is women as per section 56, judicial officers as per section 135(1). Where a matter is pending, their pleaders, muktars, revenue agents and witnesses acting in obedience to a summon under section 135. Members of legislature as per section 135. Classes of persons whose arrest according to the state government might be attended with danger or inconvenience to the public under section 55, and where a decretal amount is less than 2000 rupees under section 58(1)(a), right? So these all people, they are exempted from being arrested and being detained under the provisions of CPC. Question number 13. Section 18 of CPC provides for the answer is D, that is only the C is correct. It provides for the institution of suit in respect of immovable property where the local limits of the jurisdiction of the courts are uncertain. This is also an important section. Let's read this section. Section 18. Where it is alleged to be uncertain within the local limits of the jurisdiction of which of the two or more courts any immovable property is situated, any one of those courts may, if satisfied that there is ground for alleged uncertainty. So what is happening here is that there is uncertainty with regard to that where that immovable property is situated and within whose jurisdiction that property is situated, right? So there is an alleged uncertainty, and in case there is an alleged an uncertainty and court is satisfied that yes, such uncertainty it exists, then in that case what will happen? The court will record a statement to that effect and thereupon proceed to entertain and dispose of any suit relating to the property. So the court is going to record it in writing, and then it will do what? It will go further. It will proceed with the case, right? So it will go with the case, and either it will entertain and dispose of the case, and its decree in the suit shall have the same effect as if the property were situated within the local limits of its jurisdiction. So the decree, it will have same effect as if it was decided by a court which had the jurisdiction, right? Provided that the suit is one with respect to which the court is competent as regard to the nature and value of the suit to exercise jurisdiction. So if you are confused about the territorial jurisdiction, all the other jurisdictions, they should be up to the mark. If they are up to the mark, then only this section is going to come into play. Where a statement has not been recorded under subsection 1 and the objection is taken up before the appellate or the revisional court that a decree or order in the suit relating to such property was made by the court not having jurisdiction where the property is situated, the appellate or the revisional court shall not allow the objection. This we have done. If this objection it is raised before the appellate or the revisional court, then they are not going to accept it. They are not going to entertain such plea. But there is an exception here also. What is this exception? It is of the opinion, the appellate at the revisional court, they are of the opinion that at the time of the institution of the suit, no reasonable ground for uncertainty as to the court having jurisdiction with respect thereto, that there was no such uncertainty. If the appellate court is of the opinion that there never existed that uncertainty and there has been a consequent failure of justice, and because of that there has been a failure to justice, then in that case such objection it is going to be taken up in the appellant or the revisional stage, right? And one more condition is what? When the statement were not recorded. The statement that was recorded by the court of the first instance that there is such uncertainty. If it was not recorded, then only, right? So let's read this again. Now it will be clear. When a statement has not been recorded under subsection 1, right? So where the statement was not recorded and the objection is taken before the appellant or revisional court that a decree or order in a suit relating to such property was made by court not having jurisdiction where the property is situated, the appellant or the revisional court shall not allow such objections unless it is of the opinion that there was at the time of the institution of suit no reasonable ground for uncertainty as to the court having jurisdiction with respect thereto and there has been a consequent failure of justice. Then only they are going to entertain such an objection, such a plea, right? Question number 15. The state government may by notification in the official gazette declare that the decree of any revenue court in any part of India to which the provisions of this court do not extend or any class of such decrees may be executed in the state as if they have been passed by the court in that state as per, this is section 44, right? So it is given in section 44. So the state government may by notification in the official gazette, it can be by the notification in the official gazette, declare that the decree of any revenue court in any part of India to which the provisions of the court do not extend or any class of such decree may be executed in state as if they had been passed by the courts of that state. So it will be deemed as if they had been passed by a court in that state only. Now question for achievers. Suit in respect of immovable property where the entire relief sought can be obtained through the personal obedience of the defendant can be instituted in court within whose local jurisdiction. The property is situated, the defendant voluntarily resides or carries on business, the defendant voluntarily resides and personally works for gain. So is it 1, 2 or 3? You have to comment the right answer below. So that was all for today. I hope this was an helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.